So, good evening to you all. Thank you for joining us for today's training. We appreciate your commitment and your dedication, and we are grateful to you for your, you know, faithfulness to participate in this training. And I want to congratulate those of you that have passed your exams, those of you that wrote emotional intelligence exams. I want to congratulate you. We have been receiving some here and there. Some saying because of network, they were rushing to meet up the time, and so they could not just pay so much attention to some of the questions and all of that. We'll look into it and see how we can intervene as much as possible and how much consideration we can give regarding that matter. But I want to sincerely congratulate those of you that passed your exams. We hope that you will do better in this one. For those of you that did not do well, we hope that if you are participating in this one, you will learn from that one and then improve here. So that is it. But by and large, a good number of you did well. Those of you that were so committed and truly, sincerely committed did well. Here, I saw some names that some people that were dedicated and committed, yet did not pass the exam. So maybe because of one constraint of the order, made them not to pass the exam. By and large, a good number of you passed the exam. I'm so happy. I'm so delighted to see that a good number of you passed the exam. So we hope that this one you will do better in it. So thank you very much for joining us for today's training. For those of you that are for Lagos induction, we encourage you, if you are not paying your induction fee, go ahead and pay so that you can be part of the induction. For those of you that have paid, we'll see you on Saturday in Lagos. So thank you very much. From the Institute of Global Peace and Conflict Management, we want to say thank you for taking part of this training. It's one of the trainings that we're providing to empower our people and people around the world. It's not just in Nigeria. People in other countries, Africa, other continents, Russia. I saw people from India, from Pakistan participating in the training. So that is what we are trying to do, reach out to the whole world, not just Nigeria. Do you understand? So I want to sincerely appreciate those of you that are taking time to participate in this training. So today, I want us to continue from where we stopped yesterday. And this is a free training provided by the Institute of Global Peace and Conflict Management. We are not collecting anything from anybody. And we hope that you will take part in this training. If you are coming across this training for the first time, we are saying that it's a free training. We are not charging anybody anything. From training to certification is free. Our desire is to see a world of tranquility. So we are empowering you with knowledge so that you can use the knowledge and create a positive change in your society, in our communities. So that is the issue. So we thank you for joining us in today's training as well. So today we're going to look at Module 3 of ADR. We're looking at Module 3 of ADR. Just like we said before, if you have joined us, try as much as possible to share the link with someone, or share it on your wall for someone to see what is happening, to know that this training is going on and they can also participate from it. Just invite them to take a free training course, and I think it's going to be good. So today, what are we going to look at? Today, we're going to look at Module 3 of ADR, and we are looking at arbitration. So we're going to take a step further to look into what is entails in arbitration. All right, so, and we will be looking at the introduction to arbitration. Although we have seen some aspects of introduction and to arbitration, some of the things we may say may likely be repetition, but it's good that we take a time and look at it so that we will have deeper understanding of what it's all about. All right. So today we are going to look at introduction to arbitration, and we'll be also defining again arbitration. So we'll look at the definition and the purpose of arbitration. What do you understand by arbitration, and what is the purpose of arbitration? That's what we're going to understand in part one of this module. All right. So in unit one, we're going to look at definition and purpose of arbitration. We define arbitration as a method of resolving disputes outside of the court system, where an impartial third party, known as an arbitrator, is appointed to make a binding decision on the matter. Do you understand? So this is a process often used in commercial disputes, labor conflicts, and other legal disagreements. Do you understand? So you have business disagreement, you enter into a business with someone, and there's a need for you, there's a conflict. You deploy the tool of arbitrator to resolve it, or you employ someone, or maybe you are being discharged from your workplace unlawfully, and you feel that the way you were discharged from your duty is unlawful. You can approach an arbitrator for the resolution of your dispute. Do you understand? So that's what it means. So arbitration is a method of resolving conflicts and disputes outside of what the court system. That is any matter you are able to resolve outside of the court system that have a binding effect on you, that we call it arbitration. You understand? It has a binding effect on you. We call it arbitration. So let's look at some of the purposes of arbitration. What are the purposes, or what is the purpose of arbitration? One of the purposes of arbitration is to expedite resolution. All right? To expedite what? Resolution. That is to fast track resolution of disputes. So arbitration aims to facilitate a quicker resolution of conflicts compared to traditional court litigation, minimizing delays associated with the judicial processes. You know, the judicial process, most especially in some countries, is slower than in other countries when compared. Do you understand? In other countries, the process can be fast-tracked, but in other countries, in many countries, the process is always slow. I mean, the legal process is always slow. The judicial process is always slow. So, but arbitration, make sure that disputes are resolved with speed. Do you understand? It quickens the resolution of conflicts. So that's one of the purposes of arbitration, to quicken the resolution of what conflicts, to expedite actions or resolutions. Do you understand? That's what it means. We talk about cost reduction. When you look at the cost involvement in court cases, then arbitration offers you the option of achieving a result or the same magnitude of outcome at a reduced cost, or even an outcome that can be seen to be more beneficial and better at a reduced cost than when you take the matter to court, which is mostly even biased. Do you understand? Court decisions are biased, or an arbitral decision or an arbitrated decision can be the one that can even benefit both parties mutually. Do you understand? Because it's being resolved out of what? Court. Because here you're not paying appearance fee, court fee, this one fee, all of those fees are being reduced. You just settle the arbitrator what you people agreed upon. Do you understand? So the arbitration process is designed to be more economical, as it is often involves lower legal fees and reduced overhead costs due to its streamlined nature. All right. So we look at the privacy assurance. One of the purposes of arbitration is to guarantee privacy. There's an assurance of privacy in resolution of matters regarding you and your party or your opposing party. Do you understand? So cases being resolved under arbitration are mostly undisclosed. Do you understand? Are mostly undisclosed. In case they may be disclosed in situation whereby there is a threat to life. Do you understand? And there's need for rehabilitation, or there's need for counseling, or there's a need for other services, maybe medics or medical or health services that are required in case of such kind of instances. Do you understand? So, like we said yesterday, that a case may be disclosed. Otherwise, privacy is assured. All right? Procedural autonomy. Procedural what autonomy? That is, parties have the latitude to establish the rules governing the arbitration, allowing for a customized approach that fits the specific circumstances of their dispute. Differences values, dispute values. Do you understand? So the values of this dispute determine the kind of procedural approach you should use. It may not be applied universally. Do you understand? The situation and the need of the case, the dispute, determine the procedural approach you should use. So that's why the parties in conflict have the autonomy to decide what happened to them and how the process flows. You understand? So if you don't want a particular thing, you don't want it. If somebody suggests a particular process and you're not comfortable with it, you will not want to go with that. Do you understand? So that's what it means. So specialized knowledge. Specialized knowledge. Arbitrators can be selected based on their specific expertise in relevant fields, enhancing the quality of decision-making process. Now, when we say you are an arbitrator, then it's not necessarily means that you have a particular specialty. That, okay, for instance, now it's only cases that has to do with peace and conflict resolution that you can intervene. No, as an arbitrator that is a medical doctor, you can be able to arbitrate in medical cases. So if it's improper for you to go and bring someone who is let's say, for instance, who is a mechanic or who is an engineer to come and mediate on a medical issue, except the person is a medical engineer. Do you understand? Except the person is a medical engineer. When we're talking about a medical engineer, is those that produce medical instruments. Do you understand? And repair medical instruments. Except the person is a medical engineer. But if it's a mechanical engineer who they will come and bring them to mediate on medical cases, then you see there's an improper, that's what we call improper fraction. This one don't understand mathematics. Me, I don't understand mathematics, but improper fraction, a fraction, do you understand? So it's not going to work. They may lack knowledge, they may lack the medical application, so they cannot fit in that application. So that's why you have to bring someone who has knowledge of medical fields to come and arbitrate. Do you understand? And most especially have training and skills in arbitration. Do you understand? So they are the ones that can arbitrate. And then we talk about conclusive judgment. The outcomes in arbitration are generally final and binding. That is, when decisions are being made in arbitration, they are regarded as final. Do you understand? And they are binding. That's why they have minimal chances of appealing them. Do you understand? So they provide a definite resolutions to dispute with limited opportunities for appeal. With what? Limited opportunities for appeal. Thus, fostering certainty and stability. That is, in arbitration, you don't assume. Their resolutions are so definite. Do you understand? They are so certain. Do you understand? There's no element of uncertainty because the process is being, guided towards the outcome. Do you understand? And the parties themselves decide the procedural approach they use. So the outcome becomes so obvious and definite. Do you understand? So once the decision is made, they are considered as final and binding. Do you understand? So when such decisions are being made, they are practically not easy to appeal. They are practically not easy to appeal. Do you understand? So, but in the court case, you know now, you can appeal. You see our people now, they appeal until they get to the Supreme Court. That is from the High Court to Appeal Court, Supreme Court. Do you understand? Until it's settled at the Supreme Court, where they have no place to appeal. Assuming they have another one, they will still appeal. And some people, if they discover that if it's a matter that can be appealed at the International Court of Justice, they will take it and go to the International Court of Justice. You understand? So reduce formalities. There is what called reduced formalities. The arbitration process is often less formal than court proceedings, so which can make it more accessible and less intimidating for the parties involved. So the processes in arbitration are being, the formalities, that is, they are so, all those legal formalities that you must fulfill to a point that even cases are being determined based on technicalities. All those technicalities are not involved in arbitration. They are minimal. You understand? They are reduced formalities. So cases are not being judged on their technicalities, but on their merit. You understand? And so that's why they are always difficult to appeal, because the case is being determined on merit, not on technicalities. So how will you appeal it? So neutrality. Arbitration provides a neutral forum for resolving disputes, helping to ensure fairness, especially in international conflicts where parties may come from different legal systems. You understand? That's what arbitration also does. It guarantees neutrality. That is, arbitrators don't know, they may not necessarily, they may not know you, they may not have any formal relationship with you. You understand? So of course, they don't have interest in the case. So they are just there to provide their services. They provide their services, and whatever they have for them as a fee, you pay and you go. You understand? That's what it means. So let's look at some of the comparison of arbitration with dispute resolution methods, other dispute resolution methods. All right. So let's do a comparison of some of these methods that we have been mentioning here with arbitration. All right. Let's compare arbitration with some of those methods that we have been mentioning. And one of them is arbitration versus litigation. What are the comparison? Arbitration and litigation. Any comparison? Any differences? So we say that arbitration is private and informal. It's private and what? Informal. Parties select an arbitrator who makes a binding decision. As an arbitrator, you have the capacity and the authority to make a final and a binding decision. All right? So litigation. What about litigation? Litigation is a formal judicial process. We say arbitration is what? A private and informal. So just take note of If I ask you in the exams now, what's the difference between arbitration and litigation? You should not be confused. I say arbitration is private and informal, but litigation is what is a formal judicial process. Disputes are resolved in a public court under strict legal procedures. You follow the legal processes, and then a case is being resolved. You understand? So time frame, let's look at the time frame. So we are going to distinguish these two aspects of arbitration. That is, I'm talking about litigation and arbitration on the basis of the nature of processes. You understand? The nature of process. And they say that arbitration is private and informal, but litigation is what is formal judicial process. Do you understand? That is the nature of process. And then we'll look at their time frame. We're going to also compare them based on the time frame. All right. We say that arbitration generally is quicker due to streamlined procedures, but litigation can be lengthy, taking months or years to resolve. Do you understand? So that's what arbitration and that's how arbitration and litigation differs based on time frame. Do you understand? So the time frame of arbitration is very short, but the time frame of litigation is lengthy. It can take you are aware now. There are some cases that are more than 10 years, they have not been resolved. They keep giving adjournment. How many years is Nnamdi Kanu in prison now? In the custody of, they are every day going to court. Then the adjournment takes 6 months before another appearance. What kind of system is that? You understand? So that is the litigation. That's litigation for you. But arbitration, assuming this case was under arbitration, it would have been resolved by now. Do you understand? It would have been resolved since. So costs. Arbitration typically is less expensive due to lower legal fees and faster resolution. So if I appear today and I resolve a matter today and you pay me today, I go, it settles. But when it comes to litigation, you're going to court maybe in a month, twice or 3 times, and they're going to pay you a fee, a legal court appearance and whatever. Do you understand? Fees and all of that, and other charges that may involve transportation to the court and all of those things, and other inconveniences, time loss, and all of that. Do you understand? And they say time is money, and so you lost so much time spending time in court that you are listening to cases. So it doesn't make sense. So if you can deploy the arbitration process and resolve your conflict in the shortest possible time and save money, save time, then it will be more beneficial and productive for you than to go to court and waste several years, spend money unnecessary. So let's activate the tool of ADR and begin to enjoy it. And forget about going to court. Going to court for what reason? Except you deploy all means of every tools of ADR and they are not working for you, that you can approach the court. Otherwise, I think the court should be the last resort for you to go for any form of redress. Do you understand? Deploy the tool of ADR. It will help you, it will save you money, save you everything. So it's very important. Confidentiality. We're also going to compare arbitration versus litigation on the basis of confidentiality. Now we say that litigation are public. The process is public, the record is in the public. Do you understand? Whatever judgment is being made is in the public. But when it comes to arbitration, it's confidential, it's secret, it's the information and whatever decision made is undisclosed to the public. Do you understand? So that these are the comparison. And then we'll talk about appealability. Appealability. Do you understand? So arbitration Decisions are usually binding and have limited grounds for appeal. They have limited grounds for appeal. But when it comes to litigation, judgment can often be appealed to a higher court. Assuming the decision was taken at the magistrate court, you can take it to the high court, from high court to appeal court, from appeal court to Supreme Court, from Supreme Court to maybe the heavenly court. Do you understand? Because sometimes the loser in the court will say, I leave it to God. Let God be the judge. When the matter gets to that point, you have taken it to heavenly court. You are appealing to the superior court. Do you understand? So that is above the Supreme Court. You say, let God be the judge between you and I. You have manipulated and won. That is, they are not accepting the defeat. They say they have manipulated and won. So, but let God be the judge. So you have reported the matter to the higher authority. But assuming maybe you started with the higher authority, it would have been easy. And then you could have just deployed the arbitration tool and then ADR tool and solve your problem. Do you understand? So that's what it is. So let's look at arbitration and mediation. Arbitration and mediation. We say that we're looking at the nature of process here as well. How does arbitration and mediation differ? How do you compare them? So we say that arbitration involves an arbitrator who renders a binding decision after hearing the arguments. Do you understand? But in mediation, what happened? A mediator facilitates negotiation between parties to help them reach a voluntary agreement. In this case, it means simply that a mediator cannot give or take a binding decision. His own is just to facilitate the process, to facilitate discussion, to facilitate conversation. So understand this different. That is, an arbitrator can make a binding and a final decision, but a mediator cannot take such decision because it does not have such kind of power. The only thing they can do is they facilitate the process, they facilitate discussion, they guide the parties to conflict to arrive at a mutually beneficial outcomes for the parties involved, but not to take a decision, not to interfere, not to even speak on behalf of anybody. You understand? So the outcomes, let's look at outcomes. What is the difference here? How do you compare arbitration and mediation on the basis of the outcomes? Results in a decision made by the arbitrator, which is binding. You understand? Results are binding, and they are enforceable. Results are what? Binding. It means that they are enforceable. You can enforce those results. You can enforce those outcomes. But when it comes to mediation, parties retain control over the outcomes. All right? Agreements are not binding unless formalized in a contract. Except formalized, let's enter a contract. Except the agreement got to a point that you say, okay, let's have a written contract agreement. Okay, so agree. But if it's not done so, then the that is the decision is not binding. Whatever the mediator have done, the parties can voluntarily implement it or decline to implement it, no consequences at all. But in arbitration, the outcome, the result is binding on the parties, and there is greater possibilities of enforcement. Do you understand? That's what it means. Time and cost, typically faster and less expensive than litigation. That is arbitration, but can still incur significant cost. Can still what? Incur significant cost. We are saying that it's faster and less expensive when you compare it to litigation, but you can spend some money. But when it comes to mediation, what happens? Parties maintain what it is generally less expensive and can be resolved more quickly, and it is focused on negotiation. So it's that's to say in a simpler way that mediation is cheaper when compared to arbitration. Do you understand the difference now? That is, we are saying that when you compare arbitration to litigation, then arbitration is cheaper. But when you compare arbitration to mediation, then mediation is cheaper than arbitration. Do you understand? So if you are to spend anything, then it means that what you spend on mediation is cheaper compared to what you spend on arbitration. But it's generally more cheaper when compared to litigation. Do you understand? That's what it means. So confidentiality. So all of them, both arbitration and mediation, are always confidential. Do you understand? They are always confidential. So that's what it is. Whatever discussion we have here must remain undisclosed. Do you understand? So let's look at arbitration and corroborative law. Arbitration and what? Corroborative law. So nature of process. Arbitration is a formal process where an arbitrator decides the outcome. The arbitrator decides the outcome. Do you understand? But in a corroborative law, a cooperative process where parties and their lawyers work together to reach a mutually acceptable resolution without going to court. That is, I bring my lawyer, you bring your lawyer, and then we work together as a team. In the presence of our lawyers, we discuss our problems, and our lawyers help us together. We discuss it, we discuss the problem, and then they explain the law instances and the requirements and all of that, and conditions on the terms on the basis of law, and then they help us to understand deeply what is involved. You understand? And then will help us to resolve our problem without necessarily going to court. That's what we call corroborative law. Corroborative law. And then we'll talk about outcomes. How do you compare corroborative law with arbitration on the basis of outcomes? Decisions under arbitration, like we say, are binding, right? Binding decision imposed, they are imposed by the arbitrator. They are imposed by the arbitrator. That's the arbitrator has the power to impose decision on the parties involved. So, what about the corroborative law? No binding agreement reached through negotiation, with the goal of preserving relationship. No binding agreements. Do you understand? So, control, limited control over the final decision. Arbitration has a limited control over the final decision, right? Corroborative law have high degree of control as parties work together to find solutions. So in arbitration, parties have limited control over the final decision because the decision can be imposed by the arbitrator. Do you understand? But in corroborative laws, the parties have high degree of control over what come or become of the case. Do you understand? Because they are working in line with their lawyers to bring a resolution to their problem. So that's what it means. So focus. Arbitration focus on resolving the dispute through a definite ruling. Do you understand? In arbitration, focus on what? Resolving the dispute through a definite ruling, the ruling that we regarded as a certain, that is certain and is final, is definite. Do you understand? So, but we have collaborative law, emphasis on communication and cooperation to address underlying interests and preserve relationship. That's what collaborative law is all about. So are we together? I think you are following me. So you are following me. Try to share it with somebody, and then let them also be part of this training. Let them know that something like this is happening here. So that they can also be part of. Invite someone through share and invite someone to be part of this training. That's what I want to do. Right? And people should listen to this video again and again, because Some people fail in emotional intelligence. Some people fail the exams. Now, it seems as if they are using emotions now for us to understand with them. I know we just finished is training on emotional intelligence. And so they are trying to use emotion now to influence decisions. Do you understand? They say it's because network was so bad. I was trying to rush, and because network was so bad, so I was trying to rush when I was able to, and that's why I couldn't make it. Do you understand? They're using emotion now too. So better listen to this video again. Even now that you don't have manual, take time, go through the video again and again. Depending when you have the manual, you still listen to the video, compare it with the note, and then prepare yourself for your exam. Because the peace education examination was set by Janet, but emotional intelligence exam was set by myself. I set it. This one, I was still tighten it more. So that when you finish and you pass the exam, you know, say you pass. Do you understand? You say nah anything. You know, say you pass the exam. And then somebody will ask you anything, you can be able to defend it. It's free, but it's not, it is free. This training is free, but it is not for play. It's not a child play. It's free with quality. It's free with standard. It's not free that it's not Allah. You understand? It's not Allah. It's free but not Allah. I don't know whether you understand what I'm trying to say. So that is it. So can we proceed now? Let's look at arbitration versus negotiation. Arbitration versus what? Negotiation. What is the comparison here? Arbitration involves a formal structured process with a binding outcomes. That is the nature of interaction here. But negotiation is informal and flexible. Parties discuss terms directly to reach a voluntary agreement. You understand? Negotiation is informal. Arbitration is formal. Mediation is informal. You understand? That is what it means. Decision authority. Arbitration, an external authority, the arbitrator decides the outcome. Negotiation, parties themselves decide the terms of the agreement. If we sit here now, it's as good as okay, we are in the class here, we have a disagreement. We can discuss our issues here and resolve it and get our outcomes. When it comes to arbitration, we will discuss, and someone maybe may listen to our discussion, do you understand? And then make a decision for us. You may decide to say what people have said. I don't think that is the good idea. I think the best thing we're going to do is this one. So he will decide for us. You understand? Based on what we say to him, you understand? So confidentiality. Question is often what confidential, but can be subject. It can be subject to disclosure in some jurisdiction. It can be subject to disclosure in some distribution based on what we have explained earlier. I will say that there are certain situations that may warrant the arbitrator to expose and disclose whatever they have said. Do you understand? Most especially when cases are threatening or are life-threatening, let me put it that way. So, negotiation, typically confidential, fostering open communication, right? Fostering open communication. So, arbitration versus conciliation. Let's look at arbitration versus conciliation. Arbitration, the arbitrator makes a binding decision after hearing both parties arguments and evidences are being presented. Do you understand? But in conciliation, the conciliator facilitates communication and suggests solutions, but does not have the authority to impose a decision. Now, you can see the difference between conciliation and mediation. In mediation, the mediator facilitates the process, but do not even suggest a solution. But in conciliation, the conciliator facilitates the process and can suggest solutions. Do you understand? But it's not imposing it on the parties. The parties may decide whether to accept the suggestion or not. So you may say, I think based on what you people are saying here, I may suggest that you should consider this particular angle. Do you understand? I will suggest that you should consider this particular angle. Do you understand? Or I would consider that you should consider having a physical examination, so that everybody will travel to Abuja and have the exam in the office, in our office here. Do you understand? So that is so, but it's a suggestion. So we is subject to be accepted or not. You choose to, you can choose to say no, 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 no. How can you compel us to travel to Abuja for physical induction when we can do an examination online here very easy? Why should we be subject to go to Abuja for examination? Why we can do examination online without stress? You manage just the network hitches here and small, but traveling to Abuja, it means that you risk the risk on the road, the cost of accommodation, cost of transportation, the cost of feeding, the inconveniences of leaving your family behind, and all of those things. You understand that kind of a thing? So that is it. And the dangers of kidnappers on the road. So you prefer that you should write the exams. So, but the suggestion was that okay, take this option. You understand? So, but you say no. So it's not imposing on you. But by the time I impose the decision that you must come to Abuja for a physical exam, that's you have no choice. You have to come here and do a physical exam. That one we call it arbitration, because it takes a binding work decision. So level of involvement. Arbitration. The arbitrator actively evaluates the evidence and legal arguments presented by both sides. But in conciliation, the conciliator takes a more informal approach, often meeting with parties separately to explore options and find common grounds. Do you understand? So that's what it means. So nature of resolution. Arbitration results in a definite, legally binding award that resolves the disputes. But in conciliation, aims for a mutually agreeable solution. Any agreement which is typically non-binding unless formalized, just like mediation. Do you understand? Just like mediation. So focus on relationship. Maybe arbitration may be adversarial, that is, it may have some consequences, and it may possibly be biased. There are potentials of being biased, so potentially straining relationship due to the competitive nature of the process. But conciliation prioritizes maintaining and improving relationships, helping parties to communicate effectively and reach a consensus. Do you understand? Helping parties to communicate effectively and reach what? Consensus. So let's look at arbitration versus online dispute resolution. Arbitration versus what? Online dispute resolution, ODR. Process. So now, process medium. That is the process medium. Nature of process. Arbitration, traditionally conducted in person, though increasingly moving to virtual format as well. That's arbitration mostly happen in face-to-face on one-on-one, you understand? But nowadays, with the issue of technology here and there, We can try to do it online. Do you understand? Just like we can have our peace clinic and you are in Lagos, you connect to discuss. We can connect from a far distance and settle disputes. You understand? So arbitration can also happen like that. But OTR, that is online dispute resolution, is entirely online, utilizing digital form platforms for communication, negotiation, or arbitration. And just to have a meeting and do our online dispute. Whatever is the matter, we can resolve it here. You understand? We can resolve it here. So accessibility, arbitration, while it offers faster resolution than litigation, it can still involve logistical challenges. Logistical what challenges? Because it has some element of formal processes. Do you understand? Then we have the OTR, highly accessible, allowing parties from different locations to participate without travel. You don't need to travel anywhere. Call me, send me a text, chat me on WhatsApp, and then we'll have reasons to chat with each other. Come online, let's discuss it through Zoom, through any other app that can help you to have an interaction, Google Meet, and all of that. Do you understand? YouTube, Facebook, you can meet and discuss your problems and resolve issues. You understand? So technology use. Arbitration may use technology for presentation, but often follows traditional procedures. While ODR fully integrate technology using tools like video conferencing, chat, and document sharing to facilitate the process. I can share document. I can screen share. I can screen share document. Here you can see document. If I want to screen share this our discussion now. In our early days, we were screen sharing. We screen share our document. You see what I'm talking about. Do you understand? So the use of technology in arbitration is for the purpose of presentation, but in OTR, it can be live, document can be shared like this. Technology can be used to have a comprehensive discussion online. Do you understand? So let's look at arbitration versus traditional settlement negotiation. Arbitration versus what? Traditional settlement negotiation. Let's look at the structure. Arbitration is a structured process with defined rules and procedures leading to a formal decision, because there are some rules you follow. There are some procedural approaches you have to follow in arbitration. But in a traditional settlement negotiation, informal and flexible procedures are used. Parties negotiate terms directly without a predetermined structure. You understand? So that's what it means. So decision authority. The arbitrator has the final say. But in traditional settlement negotiation, parties retain control over the outcome, as any agreement is voluntary. So time frame, arbitration is quicker, but still requires time for hearings and deliberations and presentation of evidence, while traditional settlement negotiation can be resolved quickly, often in a single meeting or series of discussions, and then it's done. You can have a series of discussions, like you have a meeting with someone here, you go to another person, you have a meeting, and then you come another meeting again, and then come bring them together, a series of meetings, and then you discuss it. Before you know it, you resolve the case in one day. Or you can bring all of them together and then everybody share your opinion, share your own. At the end of the day, you resolve the matter. Do you understand? So we are saying that arbitration offers a structured and binding resolution process, distinguishing it from other methods like mediation, conciliation, and negotiation. Each method has its own strengths, weaknesses, and ideal context for use, because you may not use either arbitration where you're supposed to use mediation. Do you understand? So allowing parties to choose the best approach based on their specific needs, the nature of the dispute, and their desired outcomes. All right, so that's what you're going to do. So arbitration being used in different contexts, you understand? So you should determine which one that is suitable for you, whether arbitration, mediation, conciliation, anyone that is good for you, you can use it. So let's look at the advantages and disadvantages of arbitration. Are you following me? If you are following me, let me know that you are following me and you are understanding what's going on here. And those of you that are having network problem, I hope I hope you will understand. Somebody's somebody is saying that those that are using emotional techniques and tactics to help make us to bend small are using what we call emotional blackmailing. It's emotional blackmailing, and that's what Harriet is saying. Harriet, God bless you. All right. So that's what it means. So people should not use emotional blackmail to blackmail us to change our rules, to bend our rules. So, you fail exam, no consideration, right? All right. Let's see how we can temper justice with mercy. At least for the sake of those that were so committed and dedicated. Let's see how we can help them to see how they can benefit from this. All right. So let's proceed so that we finish it up before we discuss the emotional intelligence issue. All right, discuss the issue that we must discuss. So okay, so advantages and disadvantages of arbitration. What are the advantages of arbitration? Arbitration have its gains, the benefits that we can gain from it, like speed and efficiency, are one of the general benefits that we can enjoy when we deploy the instrumentality of arbitration to resolve conflicts. Do you understand? Resolve disputes. You enjoy speed, you enjoy what efficiency, and then also you enjoy cost effectiveness. Do you understand? It is cost effective. It means that the cost is not much when compared to other issues. And now talk about confidentiality, right? Arbitration proceedings are usually private. So you enjoy privacy. For those of us that love our privacy, do you understand? You enjoy your privacy. It protects your image, your reputation, and protect certain information that are sensitive that you don't want to share them in the public. Do you understand? That is it. So expertise. Parties can choose arbitrators with specific expertise. So you have the choice to decide who will mediate or arbitrate for you. So you cannot go and bring somebody who is a fish farmer to come and arbitrate in a matter that concerns and crop production. You understand? Crop production. So let's have when it has to do with crop production, look at people that are specialists in agronomy. You understand? In crop production. You understand? How do you call it? So they will be the one to decide. Right? So let's look at flexibility. So another benefit. You can tailor the process to suit what you want. It's flexible. And then finality. Yes, you are the decision is typically binding. Okay. So and then it makes no room for appeal at all. So the outcomes are certain of certain, do you know, certainty in outcomes. Then we'll talk about neutrality. Arbitrators can provide an impartial perspective, especially in the international dispute where parties come from different legal systems. All right. So they come from different legal system. Like for instance, Nigeria versus Cameroon. Nigeria, Cameroon, and the International Court of Law. Although that one it was, but it can be arbitration can be applied, and then Nobody have interest in Nigeria. Nobody have interest in Cameroon. So whatever decision they decide, it's final. Do you understand? So neutrality is also one of the things. So reduce formalities are the things that you are going to enjoy so that you don't go through unnecessary stress and procedures. So these are the advantages that you're going to enjoy when it comes to arbitration. But when it comes to disadvantages, what are those disadvantages of arbitration? We have limited appeal options. One of the disadvantages is that you cannot appeal the outcome because we told you that it's final. You understand? The outcome is what? Final. And it's binding. So it has limited chances of appealing. So it makes it very, very, very difficult to appeal. Do you understand? Then there is also potential for bias. These arbitrations are human. Like I said, somebody may not just like you, and they may just personally want you to lose the case. Maybe the way you are so talking, maybe you are talking so pompous and then so arrogant. So man, it's somebody that doesn't like people with arrogance and pride. So automatically, they may not like your kind of person. Do you understand? And then that will be also affecting their sense of judgment. So before you know it, they may be biased. Do you understand? So that's what it means. So if not carefully selected, arbitrators may exhibit bias, particularly if they have ongoing relationship with one of the parties. But it may be other factors. Spontaneous factors may also influence the decision of an arbitrator. Do you understand? So that's why if you approach any arbitrator, try to understand the person you are also trying to deal with. Is it somebody that doesn't like people with arrogance and pride? If that's the kind of person you are going to deal with, then drop your pride. Drop your pride so that you will not have problem with the person. You understand? And then it affects the outcome of the process. So cost can still be high. Cost can still be high, depending on how long the process lasts and the environment where you find yourself and the nature of the people involved. Do you understand? The arbitrators involved. So it can still be high. You understand? But not as compared to litigation. Then we'll talk about lack of formal discovery. That is, evidences that are being, presented in arbitration are not as comprehensive as in litigation. So, which could disadvantage one party if they lack information. So, once another party does not have the power to go and source for such kind of information, automatically they stand on the disadvantage. But in a situation whereby it's a legal system, you have your lawyer that can also go onto such evidence and discuss and discover information that will help to argue case in the court. Do you understand? So unequal bargaining power. One of the disadvantages of arbitration is that in situation whereby one party has significant power or resources over another, then the process may skew in favor of the stronger party. Do you understand? So this thing can be controlled, but we are just talking on the basis of the fact that we are human, and human being can be influenced. Emotions can also influence certain things. Do you understand? So the tendency of favoring and ending to support the stronger party is there. Limited enforcement mechanism. Although arbitration awards are generally enforceable, the enforcement may be complicated in jurisdictions that do not recognize or support arbitration agreements.